Hafa adai and good afternoon, everyone. How are you doing? This public hearing conducted by the Committee on Land, Environment, Housing, Agriculture, Park, and Infrastructure is called to order, and the time is 2:01 p.m. Today's date is Wednesday, November 12, 2025. Notice of this hearing was disseminated to all local media outlets on November 4, 2025, with a second notice provided on November 10, 2025. Notice of the hearing was made known on the legislature's website and the Government of Guam public notice portal. This afternoon, the committee will hold this roundtable where we will be discussing Bill number 175-38 COR, an act to amend subsection 61541B, C, and F, 61546 and 61547 of Chapter 61, Title 21, Guam Code Annotated, relative to making practicable improvements to the Guam sign laws. I will go ahead and we have those who will be testifying again on the roundtable this afternoon. Director Arreola, Richard De Vera, Kaylin De Vera, Chris Morado, Kiko Crisostomo, Tejo, Ed Perez, Benson Ayong, and Bobby, right? Bobby, right? You're here? Yeah, okay. And I'd like to thank my Vice Chair for being here this afternoon, Senator Duenas.
Thank you, Mr. Chairman.
Thank you, sir. Before we begin, I would like to go over the general rules of conduct. Individuals testifying shall state their name for record-keeping purposes. Discussions will be confined to the substance or nature of the agenda. Personal interference as to the character or motive of any senator or individual testifying is not permitted. The chairperson of the committee may order the removal from the hearing of any member of Ilesa Turang Guam who fails to observe proper decorum pursuant to the standing rules of the 38th Guam Legislature. The committee held a public hearing on Bill number 175-38 COR on September 8, 2025, and due to testimony presented and the discussions that took place during the hearing, we thought it would be best to convene a roundtable so that we can further discuss the bill and how we may improve this legislation with input from the stakeholders and community partners. Bill 175 does two main things. First, it standardizes the definition for electronic signs as digital signs. There are currently multiple terms used to describe the digital signs that include flashing, electronic, lighted, etc. There are others. The other is to be mindful of everyone's right to equal protection under the law. Guam digital sign laws give preference to some businesses and shut the door on others. This is the result in the legislature in the past, assuming the role of the sign permitting agency. I don't think Guam wants to be a neon city. Guam's laws, however, allow signs for some businesses and not for others. Therefore, business owners must lobby the legislature for changes to the law or make their cases, or take their cases to the court for lawsuits. This bill is not intended to add a specific business or businesses to the list of those that want to advertise by digital signage. It simply makes the signs law apply equally to all the businesses. Although both the Guam Land Use Commission and DPW are involved in the issuance of sign permits, the current law provides zero flexibility to both the GLUC and DPW to provide any variances to the sign regulations. As such, any business seeking a digital sign permit must lobby the legislature. Those who testify against the bill at the hearing oppose the bill's elimination of the certain sign regulation. The result of doing nothing, however, will have the continuing lobby of the legislature for variances. There has to be a better and fair process to help businesses and at the same time preserve the natural beauty of the island. With today's discussion on Bill 175, the committee is aimed to provide clarity for all parties involved as to the intent of the legislation as we move forward. I'd like to also thank my colleagues, Senator Chalahi and Senator Taidigui, for being here this afternoon. So we'll go ahead and start with the director for the testimony, sir. If you have any that you want to provide.
No pun intended. I'll punt on this one. I've read it 2 or 3 times. I'm still trying to figure out the basis for this. Yeah. But obviously, I can see how it only applies to commercial zones, industrial zones, and I think you're taking some of the stuff out of the 2-1H zone.
Right.
Right, and so I was trying to figure out who's the actual author of this to see what's the end game here.
Well, I think the end game here is just to try and make it a level playing field for all, right? As you always, have you noticed in the past where there's no room for variances, right, with DPW or GLUC, and that's why everyone keeps coming back down here to the legislature to lobby us to, we need to do this, or, yeah, exactly.
Put one here, put one there.
So if we can just make it an equal playing field for signages, whether you're digital or you're static, or, you know, what is it that we need to do, and how do we move this process forward?
I'll tell you Mr. Chairman, one of the most important issues coming from DPW is, you know, we run the Office of Highway Safety.
Right.
It's a federal program. And their big issue is how these signs impact drivers, whether it be daytime or at nighttime. You know, when you're driving a 3,000 or 4,000 pound vehicle going at 20, 25, 30, 35 miles an hour, your attention has to be on the road. It can't be on some sign flashing something here or another sign flashing there. So that's one of the issues we really have to take into account when we talk about digital signs. And I get it, right? The new age is here. Everything's going digital. You can really get the individual's attention, and so there's got to be some balance to make sure that we take care of our drivers as well.
Yeah, definitely. So DPW and GLUC have no room for variances, right? And they always have to come back to the legislature. So what is it that we can, what is it that we can do to just make this an equal playing field? How do we make the bill better, stronger, and safer for everyone?
You know, I think you certainly want to, there's all kinds of things you talk about. You talk about the size, you talk about the luminance, you talk about the brightness. I think you need to talk about the certain areas where you're going to put this. You know, in some crowded areas, say like Tumon versus the Strip going down Sumite, right? That's all. They're two different highways. They're two different roads. But you know, just depending where it's at, you could have and you will have impacts on drivers that traverse whether it be Marine Drive or Route 2 or any of the different routes. So a lot of it has to do with location, and I think we have to be real careful about where we put these signs. And a lot of it is it's a policy call. How many signs do you want? Do you want them all over the place, or do you want to just keep them limited? I actually had my staff go out and look. We haven't gotten any results yet, but we're looking for stats throughout the nation in terms of how these digital signs impact roadways, highways, freeways, and speed limits. You know, because there's also an impact on your speed. If you're traveling, say like you're in Vegas, right, and you're in the Strip, speed limit on the Vegas Strip is what, 10 to 15. So you're going at a really slow pace, but there's lights all over. But your speed brings you down, so your risk is a little bit less, I think, and I think there's a reason for that. If you're on a highway with 5 lanes on one side, another 5 lanes on the other, and you've got blinking billboards all over the place, that's a different environment for drivers. So that's got to be taken into account. Obviously, we don't have 5 lanes here, but we have some areas where there are 3 lanes. Lots of areas of Marine Drive have it. So just a lot of things to take into account.
Okay, thank you. So what we'll do is we'll just go ahead and go around the table, kind of get the input from everyone, and then see how we'll move forward from there. Mr. De Vera, Rich, you're up. You wanted to give some input on this legislation? I got you and your boss there, so please be sure you represent your boss and state your name. Huh? Both of you.
Kalen De Vera.
Richard De Vera with Cherry Media Vision. I just wanted to see if we can move this forward as far as getting some dialogue going with a lot of the stakeholders to see how we can kind of amend the current law where we can kind of like move ourselves into the future by creating what regulations, some sort of control in our industry. That's basically what we're looking for. Give us like you said, like a level playing field too. Because with everything else that's moving forward with technology, especially with our youth and messaging in general, I think I guess our industry plays an integral part in actually getting messages out, whether it's PSAs, advertisements for our vendors, our business partners, and that's basically it where we're coming from.
Okay, so that's what you're also looking for, is a level playing field as well, huh?
Yes, because I mean the law is antiquated. I mean was done like in the 60s or 50s whenever it was written, and we're deep into the 21st century already. So I think it's time for us to kind of take a look and see how we can have it kind of cohesively mend with our values locally and within the villages and so forth, and also on the business side too as well.
Yeah.
Because we don't want to create distractions. We just want to help. Excuse me.
Okay. All right.
Okay.
Thank you. So we'll go ahead and go on to Chris Morado now. So,
Half a day.
how about you, sir?
Thanks for having me.
You're welcome. I just wanted to thank my colleague, Senator Borja, for being here as well. Thank you, sir. Go ahead, Chris.
Thank you for having us. First and foremost, I want to say thank you, senators, for putting forth this bill, because it is really needed, because it is an antiquated sign law that we have. I think it's over 40, 50 years old now. I know there's been some modifications to it based on, for the H zone, hotel zone, that was included, I think, in 2019, with some very strict regulations, which we were involved with as well. Now, the current bill that's being proposed, unfortunately, we didn't support because there's no regulations whatsoever. It would have just opened up the floodgates to building any type of sign anywhere at any size. No regulations in terms of illumination, size, or I believe zones as well. I'm not sure though. So as I said in the public hearing for that bill at that time, we actually worked with Senator Tom Atta, Will Castro, and several other senators back in 2017 on a bill that was actually passed by the legislature at that time. That bill number is 154-34. And that bill we worked on for about 3 years. We sat with all stakeholders, including the public, and we came to a consensus that there's several things that we should put in place to regulate the sign industry, because it is very beneficial for the public in terms of PSAs, Amber Alerts, emergency alerts, things like that, as well as private industry where they can affordably pay for advertising on these billboards. So we did come up with a very, in my opinion, very good bill at that time. Unfortunately, it was vetoed by the governor at the time. But in that particular bill, we have lots of regulations that we recommended, and we put it into place. Regulations in terms of size, which is the maximum size of the signs, which we had on the bill was 200 square feet. And that was based on studies done by the Association of Outdoor Advertising, as well as federal highway safety standards based on miles per hour of the speed limit. So I have the documents that show this, but based on our rate of travel here on Guam, which is 35 to 45 miles per hour, signs should be no bigger than 200 square feet. And that's what that report showed. And then also, we also had distance between, because we had a big concern from the public as well as ourselves that we didn't want to flood the island with these billboards. We didn't want to look like Las Vegas or Los Angeles. We are an island, tropical island, you know, that house or welcomes tourists, that loves the beauty of the island, the ocean, things like that. So we don't want to become a Manila where there's signs everywhere. So we also had in that bill distance between each billboard, which we had on the bill was 3,500 feet. And we used studies in the US, and all states that allow off-premise advertising have these regulations in place based on size and spacing in between each display. So there's many reasons for spacing in between each display. Number one is safety concerns. When you're driving, if you have lots of displays, you're going to look at a lot of displays. Number two, you've got signs on buildings for all these businesses have their signs. So if you don't have spacing in between, these billboards will be blocking those signs, which have been proven in the US with lawsuits from lots of companies, you know, saying that their sign is blocking mine. So that prevented that as well. We also had regulations of the distance from intersections, stoplights, right? The bill that we drafted up followed federal highway standards, which is 100 feet from intersections. And then there were several other things, illumination as well. So illumination had to be adjusted based on the ambient or the brightness of the ambient brightness at the time. So if it's really bright outside, then the sign is allowed to go up to 100%. If it goes lower, like at sunset, then it drops down automatically. Nighttime, it dropped down automatically based on sensors. So these are the things that we put into place, as well as we put some teeth into the law as well. So we put stricter fines for people that violated the sign laws, which was, I think it was $1,000, and then if it's not fixed by 10 days or 15 days, something like that, then it's $300 per day at that point. And all that funds was allocated to the general fund. We also had a permitting process that went through DPW, which with a registration fee of $400, non-refundable registration fee of $400. We also strictly said that signs cannot be in residential or agricultural zones, only in commercial, industrial, hotel zones. Let's see here. We also specified the height of the signs that cannot go above 30 feet, which is, I believe, the standard here in Guam for buildings. Cannot go wider than 25 feet, cannot be taller than 20 feet for the display. We had the spacings like that I mentioned before. We had the setbacks defined, which is 10 feet from the edge of the property. We had the number of faces per sign, which is a maximum of 3, so that you don't have 2 signs facing the same direction, which causes distraction. Again, proven by studies, like he mentioned earlier. I believe that was it. The main key things that I believe this current bill might want to look at to include, so that we can regulate this sign industry on Guam so that it doesn't negatively affect tourism and the lives of the people that live here, that enjoy our island. Thank you.
Thank you, sir, for that. We'll go ahead and go to Mr. Tay. Are you going to speak, or Kiko?
I'll go ahead and speak on behalf of both of us.
Okay.
Yeah.
Thank you.
So yeah, thank you for the opportunity. My name is Tay Oh. I represent Vantage Advertising. As Chris mentioned, there was a legislation that was put forward about several years ago. I could actually brought the bill with me here. It's a bill 154-34. It was passed, but as Chris mentioned, it was vetoed, and I think that was the last session of the year for that particular term. So the legislature never came back to even to consider an override. But a lot of the conditions in here that Chris exactly talked about, our concerns about flooding the market, ensuring safety of the screens itself, ensuring that it's not a disruption to society, ensuring that the brightness is controlled, because these are concerns, these are real concerns, because when you don't control that brightness during the evening, it could really just blind people, especially when they're going through certain intersections. So all of that is in this bill. I'm not going to repeat everything Chris said, because that's exactly the concerns we had. But there are several things I did want to mention. I firmly believe that there has to be a certain restriction on distances between signs, just because, as you mentioned and as everyone is aware, we don't want to flood the island with digital signs being everywhere. We're not Las Vegas. We're Guam. Right? So that's another consideration. And then secondly, I think in terms of sizing, I think there has to be a certain limitation. Of course, we'd like to have a certain clearance from the intersection. Those are conditions that are all within the draft bill that was produced some time ago. I think this might be a good reference to take a look at if there are any additional provisions that you would like to input or consider for the existing proposed bill. So I think this is a good reference to start from, so please do take a look at this in detail.
Sure, you can go ahead and...
Sure.
I'll take it from you and we can...
Yes.
Thank you. All right. Anything else?
No, thank you for the opportunity. As Chris mentioned, we're trying to be in a responsible industry, but at the same time, we're also trying to make sure that, everyone has an equal playing field when it comes to this industry. So
Yeah.
please take that into consideration.
Yeah, definitely. And I think that's what's important here, right, is we bring everyone to the table to kind of figure out, update our sign laws and see how is it that we can move forward with it, right? Mr. Borja, I see you back there, sir. Would you like to come up so that we can get your testimony after Mr. Benson here?
Thank you, Mr. Chair. My name is Joseph Borja. I'm the Director of the Department of Land Management and also the Executive Secretary for the Guam Land Use Commission. I'm not here on behalf of the Land Use Commission relative to the bill, as the Commission itself as a group has not reviewed the bill. I am here actually as Land Management, and I would defer any testimony on this bill to the Office of the Attorney General, our lawyer. In 2017, there were a couple of applications, signed applications that were declared, and maybe Senator Terlaje can help me on this, ultra vires. I don't know what that means really, but it says a few words after that. The applications are ultra vires and therefore void. So I think what needs, and I have two letters here from the Office of the Attorney General, but I will not release them to the committee. It might be a client attorney privilege. I would defer to the Attorney General to release those two letters concerning the sign thing. I think the basic thing is on the previous letters is that does the Commission have the authority to grant variances for signs, I think. Okay. Thank you.
Thank you, sir. Appreciate it. Benson, you can go ahead and...
Thank you, Senator. And first of all, thank you all senators to be present and put this roundtable together, which is something we've been waiting for like 10 years. So my name is Benson Aoyang. I represent Cube Inc. I'm here strictly for the static sign billboard. We don't do digital. However, I do have many questions and comments on this bill that is drafted. I think it needs to look at closely. I don't think that just going through the sign zone law and crossed out all the restrictions that is in place, there's a reason for that to be in place. We hammered that out for a long time. And just crossing it out, I think is a little bit irresponsible. I think we need to look at closely, and it's probably done by, we have a lot of colleagues here from the digital world. You know, they have a bill back in 2017 or something like that you mentioned. I think all the digital information is there, and you know, it's more responsible, and you know, I'm sure they're going to be presented to you. But for me, it's just for the static sign. Static signs been around, what, 1,000-year banners, been 1,000 years back in the Roman days. They make their own banners. So, you know, banners everywhere on this island, you know, already. And even our billboard, in the one in Upper Tumon, it's been around, I think we'll be celebrating 10 years pretty soon. I think next year or this year. Anyway, you know, the fact is, it's proven, and there's no issue with it as far as traffic safety-wise or any complaint from the communities or size and everything. So what we want to do, just want to just continue the, you know, what we already have proven. So for us as well, you know, we had a bill, you know, back in 2019 as well. And for us, it's fairly a simple addition to the existing sign law, rather than just crossing out the existing sign law to just, you know, everything goes. You know, it's just to add an extra section. And there are really basically three things that we need to cover for the static sign, because there's no real light coming from it. You know, the flood lamps are, you know, facing the sign. You know, so some of the stuff just compared to a digital sign, it's two sets of rules basically, and ours is fairly simple, just banners everywhere, so you can see it already. So the first thing that we just need to cover is that we need to legalize or set the definition of off-premises signs, and that should go for static sign as well as digital sign as well. Off-premises sign means sign that promote activities or products that don't sell on the property, right? The second thing is the size. So the size currently that we have is a 20 feet by 20 feet sign. So basically 400 square feet. And that's, you know, we're not seeking anything larger. We're just seeking whatever that is already works. That, by the way, that was approved by GRUC back in 2016. I mean, I don't even need to talk about the height. The height is same as all the digital signs, about 25 feet, less than 30 feet, which is a zoning law. You cannot have anything higher than 30 feet. So we're sticking with that. And then the last thing, the distance. So the distance is that we're seeking is 500 feet, which came from the matrix. Basically, what this matrix shows is that all the states in the United States, basically how far the static signs can be installed. So it's 500 feet. So that's where we got the number 500 feet. And basically, that's really it. And rather than crossing out the existing law, because the existing law, it's a law governing the on-premises sign. If you remove that, then it's wild, wild west for everybody. So we're just adding an additional section for off-premises signs, and basically to cover specifically for off-premises sign. And that's pretty much. Thank you.
Thank you. Mr. Borja, go ahead.
Thank you, Mr. Chair. I know I promised I wouldn't say anything about the bill, but
No, please.
I just need a little clarification. You know, we have all these different kinds of sign, and thank you, Benson, for being here. What is the classification of that Dutch boy sign sitting on top of a 30-feet building in Benson? What kind of sign is that? What do you call that?
Well, first of all, that's not my sign.
Different Benson.
That's a different Benson.
My apologies.
I get it every day.
But I was just curious, you know, what is the classification of that sign?
And that's something, right, that also needs to be addressed in everything that we're
If I may, that is an on-premise advertisement because the Dutch Boy paint is a vendor utilized by Benson Hardware on the property itself. So that would be considered on-premise.
What is it?
Static
not
display.
digital, static display?
Static.
Illuminated?
He doesn't wave.
Well, it
he
doesn't
doesn't.
move.
Yeah, so
Illuminated?
It's obviously part of a logo.
Yeah.
Yeah.
Well, yeah, you're right. It's an on-premise sign, so it's governed by the existing rules. It's definitely not a digital sign, so
Yeah.
it's a static sign.
And it's below 30
Yeah.
feet, so.
Yeah. I mean, a mannequin, it's a mannequin.
Yeah, and you see, I think this is what this is for, right? I mean, this is what we need to discuss, the parameters, things like that, because if I didn't bring this bill forward, none of you would be at this table today, and none of you would have been at the public hearing in September. So at least we're getting somewhere now, right? And now we got a ground basis of where we want to go, how we want to do things, what is working, what is not working, what's acceptable, what's not acceptable. So these are the conversations that we need to have, and I'm grateful that, you know, Land Management and DPW came here today so that we can have this discussion. And, you know, I'm going to open the table to my colleagues and see what kind of questions, and hopefully we get more answers, and how is it that we can make this bill better, or if the committee needs to amend it or substitute it, then these are the things that we can look at as well.
Especially for land management, Mr. Chair, thank you very much for that, because we have a signed application actually on the,
Yeah, definitely, and that's what we want to do, is make sure that land management is the process, right, with the GLUC and DPW. Vice Chair, do you have any questions, comments?
Susmasi, Mr. Chair. Sir, do you have any testimony?
Yes, actually, I just wanted to add a few. My name is Bobby Sachdev with TriVision Media. We've been with TriVision. We've been at this for well over close to 2 decades from the start. We've gone through the processes of going through variances, and then change of leadership, then go through the variance again, and then, you know, just keep on pushing at it and being persistent and educating the legislation, the DLM and the public, as well as the legislature, of how the process may work. But in short, I wanted to first thank you for bringing us back to the table once again. And, you know, there's some key items here that need to be clarified and identified, and we all need to know what the differences are. These key points are the differences between digital and static, okay? Just like Mr. Director Borja just and was mentioning also earlier, that digital and static, and also keeping in mind the brightness and safety concerns. We've been part of the National Outdoor Advertising Association of America for well over 15 years now. And there's a ton of information, just like Mr. Benson had pointed out, it's all there, but they have to be relevant towards the speed, your location, and what your purpose and intent is. Because we can throw out data and all that will fit what we want to, but at the end of the day, we want to make sure it's going to fit what the intent actually is for our island. Okay, the number 3 point that we want to clarify is areas and zoning, and the next one is the difference between on-premise versus off-premise. By leveling the playing field, does that mean leveling the playing field for only off-premise, or just also for the on-premise advertisers? If we're going to allow for digital signs or static signs at 200, 300, 400 square feet for on-premise advertising, it's going to be a cluster of signs everywhere, because the cost to do so without any strict regulations is going to cause a lot of unhappy neighbors amongst each other. I mean, it's just no doubt it's going to happen. People are going to block signs, people that built their signs, and some of these signs are built out of concrete and as a standalone sign, not necessarily that and they still could be static, they don't have to be digital, but if one builds another one with a steel structure 500 feet from it, right in front of it, you just block the sign that this guy just built for and got permitted for, and even without the variance, they got permitted for many years back. Now, what happens to those guys? So all of these needs to be go into the thought process when coming up with a final answer. But one point that I wanted to make clear is that we had a process. It was the variance process. That variance process, through the act of the AG back in, I don't remember the exact year right now, put a stop on all sign variances. Now, with the new AG, it is my understanding that, that what the AG did previously by putting everything in halt is not legally, should not have been legally enforceable thereafter. Because that's the interpretation that I was told verbally from the current sitting AG's office. So it would just be a point of clarification whether, if it's true, if it's not true, because if it is true that we could go back and go through the variance process, then well, we have a pathway to do so within our regulations and a board or house to listen to what we have to say so we can justify what it is that we need to gather that variance. Those are the main key things that I want to bring up. Thank you.
If I may add, just a little bit of, I got to head out soon, so I'll just maybe provide a little bit of history behind the variance situation and how this came to be where it is. There was a time when, I'm aware of this because I used to serve as the chairman of the Guam Land Use Commission, and it happened during my tenureship, so I'm very aware of it. During the time, there was a question as to whether Guam Land Use really had the authority to authorize variances when it comes to signs. If you take a look at the Guam Land Use, the zoning code, there are certain provisions that say, okay, when it comes to height, if you go above a certain height, then you need to go in for a variance. If you want to do certain things that are not within the law, then you need to go in for a variance. When it comes to the sign law, that condition was never there. Meaning there's no condition that says if a sign wants to abide by these rules, it's fine, but then if it wants to go above and beyond that, then you're going to have to go in for a variance. That was never there. So there was a time when the question was posed to the Attorney General, and this is prior to Elizabeth Barrett Anderson being the AG, and there was a previous AG, I can't quite remember, yes, and I believe that he put out an opinion saying that Guam Land Use had the authority to approve sign variances, and that's the opinion upon which Guam Land Use Commission approved the first sign variance here on Guam, which was actually Tri-Vision Media. Now, subsequent to that, there were additional applications, but by the time there were additional applications coming in, the sitting AG at that time, which was Elizabeth Barrett Anderson, basically said that Guam Land Use no longer had the authority, and so therefore any sign variances that were approved in 2016 were null and void. I think that's what Director Vince Borja is referring to. Subsequently, following that, there was action by the legislature to grandfather in any sign zone variances that were approved, because remember, the AG came out and null and voided that 3 months after all the applications were approved. So the industry didn't feel that it was fair. And so there was movement within the legislature to grandfather in any existing sign variances that were approved by the Guam Land Use. But it was at that point where everyone kind of came to terms that, hey, if the AG felt that way, then the Guam Land Use was not going to approve any further sign variances. So that's how the door was closed during that time. And that's why there was movement to update the sign law instead of going through the variance process, because the AG felt that the Guam Land Use didn't have the authority to do so. Now, that's one clarification I think we need to make. I had no problem with going through Guam Land Use Commission. Guam Land Use Commission, the amount of study that you have to do in terms of all the different applications and all the different approvals that you need to get in order to get that sign variance is phenomenal. I mean, it's extraordinary. And it's a way to protect any type of new sign variances that may come up. So, I mean, if that is a valid process, maybe that's something we need to fix. So there are several considerations I think the senators need to make. And there's several options also. So that's something that I'd like to kind of put on the table for consideration. Okay, thank you.
And thank you for that, because I think that's important to note, right, that you guys weren't authorized to do any of the variances, so, because it wasn't in the law, right?
It was, so it wasn't clear in the law.
Right.
It wasn't clear in the law. A previous AG said Guam Land Use did have the authority to approve sign variances. Now, during that time, Attorney Elizabeth Barrett Anderson felt that Guam Land Use didn't have the authority to approve sign variances. So it really depended on the AG's opinion, right? So, and because the law isn't clear, if the AG says so, then we're going to follow the law.
Right. Okay. Thank you. Mr. Vice, go ahead.
Excuse me, Mr. Chair, and thank you everyone for being here again. So I'm not a member of the bar, but I did a quick study, and ultravirus is acting outside of the authority, meaning I guess what you're operating on, maybe, Mr. Boer, is the fact that the legal opinion from the Attorney General was that the authority wasn't vested in the commission to do that and to grant that sort of variance and that authority. So I think that anyone probably proposing to do a sign would, shy away from there, not if it's not in conformance to current law, just knowing that any complaint could deem their investment as being, a waste of resources. So I think what I'm hearing is, particularly by this group, and I want to thank you for the work that you put into it. I haven't, talking to the chairman, and I guess we're going to go through and look at the veto message on 15434. But Vince, maybe I can ask you this, Director of DPW. Have you had a chance to, or do you, were you aware of, I know you probably weren't there at the time, but 15434, can you review that bill and see if it would be enforceable for you?
Sure. I'm not familiar with that.
Please.
I'm not familiar with that bill. I could certainly take a look at it. And
Yeah, I'm just thinking that, because more than likely, obviously, I think we're going to mark this bill up under some fashion. I think the author has already done some markup to it. But I'm just thinking, from what I'm hearing from the consensus of those who put in the work to create the legislation that was vetoed, I'm thinking that maybe the consensus today is that's a starting point as working with incorporating those, perhaps if it's the will of the chair, the will of the body, the will of the author, to at least consider that as a launch point. And then perhaps getting input again on that and see if that's something that's, because Vince, I think the biggest thing, this is what I would see, other than maybe sizing and some other things that those who wish to provide this service, right, may have in mind outside of what's currently allowed. My thing is that even when you come up with a consensus on regulation, a consensus on what at least was agreed upon at the time, enough to get 9 votes with 1 absent and 4 voting nay, to do something about this issue, is I think what the author's dealing with, and I'm grappling with too, is there's a sense of discrimination. Although we have to have laws and we have to have regulations, what would it be even when, say for example, 154 were something that was incorporated with some changes and that became the law? How would you apply distance? Would it be, what in your thought right now, and even with land management, would it be a first come, first serve, where somebody came in, they got their sign, that means something in front by 3,500 feet and something in back by 3,500 feet? That's your benchmark if you're going to apply for a sign, that follows the law.
yeah, that kind of almost, that basically speaks to it, right? First come, first serve. if we put in distance measures, right? So that you certainly got to take that into account. The size limit, I'm still grappling with the size limit, whether it's 200 square feet or larger or smaller. Distance is a big thing as well. One of the things that I didn't see here is mounting also. You know, are these going to be typhoon proof? I don't know if you folks, anybody lived in the Jonestown, Parisville area, but after Typhoon Mawar, some buildings, I won't say who, but every single one of their solar panels just littered all of Parisville and Jonestown. You know, we don't want these signs out as well, and I'm sure there's a certain code as to installing and manufacturing these signs. And I think we're also talking that all these signs will be on private property, right? We're not looking to get an easement or an encroachment permit from the government of Guam to erect them on government of Guam property. That's because I don't see that in this bill either. And then the other one was on, I think it's on page 11. They deleted the provision that says it shall be unlawful to erect a flashing digital sign. So that, to me, that tells me if you take that out, then a flashing digital sign is in. To what extent? You know, one of our biggest issues at DPW is how it's going to impact our drivers, our motorists, and the traveling public, you know, whether it be a clear night, whether it be a rainy night, whether the roads are slippery, whether there's a lot of traffic. We have to take that into account. And of course, the distance between signs, you know. A lot of that, I think a lot of that has to be taken into account here.
So I guess maybe I want to just get the regulatory agencies on the record. Obviously, and I really do sympathize with the author and at least approaching this issue of, in the past, it's been, you go through the variance process. If you're lucky, you know, if you put enough research into it, chances are you may just get it through and be awarded and be able to do something that everybody else can't do, basically. So we've got to have something, guys, and I hope that that's the commitment here. We got to have something that does do something about having a playing field, whether it's level in individuals' interpretations or not. It just seems by having basically nothing and having had a process that was just, I think, maybe could be skewed as preferential, although the individuals put the time and the work into it. I'm not knocking you for it, but I'm saying it's still probably something that the average Joe wouldn't be able to do. Would have to have the wherewithal and the know-how and the resources to be able to navigate the process, right? So that's my current observation. I want to put more work into researching, and that's why I'm asking, you know, if Joe and Vince can go back and take a look at this and then see maybe if this is a launching point, that maybe this gets tweaked at some level as well. But Mr. Chair, that's sort of my comfort zone at this point. Maybe I can just see if we have consensus around the table to adopt a working process off of 154 going forward. Mr. Bora, DPW, or
Mr. Chair
Management.
and Senator, on that kind of like first come, first served basis, you're going to have to be really, really specific on that, because different applications don't proceed at the same time. You know, there could be an application that moves further down the process faster than another application, for the same general area. So that's one thing that I don't know, is it when it's submitted and accepted by the planning division that's what it is? Their first come, first serve, even though it may not have been approved at that time, and then somebody comes in second and has their paperwork in order and everything, and it gets approved faster like that. And then the other issue about keeping it on private property, I do know that, and just as transparency and disclosure, I worked with Senator Tom Ada when they introduced, I think, the first sign bill. So I know that at that time there were several mayors, several municipalities that were trying to work with sign companies to put up a digital electronic sign in their village. I know of about 3 municipalities that want to do that.
Yeah, so I don't know. I just want to go around the table and see if there's consensus on using 15434 as a launch pad to work on again.
Absolutely. Sorry, yes, absolutely. There's a consent on our side with TriVision that we would love to be able to be at the roundtable and continue working on what we've already been put a lot of work and time and effort on for Bill 15434.
Same with me, Chris Morato. We're on the same page with TriVision Media Group. I think it's a great starting point to look at. And thank you, Director, for all your concerns, because all of those concerns were the same concerns that we had back in 2017 that we addressed in this bill. So you'll see as you read through this that a lot of those questions are already answered in this bill. So it's a great starting point for your department. And then in terms of the distance between and the first come first serve thing, this system of having a certain distance between each sign has been implemented in all states. And because of the reasons that I mentioned before, you know, the distractions, blocking other people's signs, things like that. And it would be in this bill, it is first come first serve, but there is a limit to how long you have to build the sign. So if you fail to pass that limit, then the next applicant is now eligible to get that. So again, all of those questions are answered in the bill already, and that's why we stand very strong in the fact that this is a great starting point at this point. Yeah, thank you.
I'm sorry, what was the question?
So my question is that trying to get somewhere to move off of open-ended and even the current with some amendments already having been done by the author, is there a consensus that we use 154, a previously passed bill by 9 yeas, 4 nays, 1 absent, as the launching point to substituting this bill or working on this bill to try, is there consensus at the table here that that is an appropriate vehicle?
Okay, well, you know, I'll be happy to share as much information you know, regarding billboard signs, you know, from, you know, other states as a baseline, something that, you know, you can, you know, use for the bill. And, you know, same as TriVision, you know, we're also a member of the OAA, which is the Outdoor Advertising Association, which they compile a lot of information for static sign and digital sign. And it's important to understand that the two type of signs are not the same. Obviously, we don't have to noise, light pollutions or brightness, you know, and other concerns that they have regarding digital signs. So it's important to separate the two as far as the different sizing and distance and things like that when you look at. And I'll be happy to offer the information. And I'm sure that bill covers a lot of the digital side. The digital side, I think I think it's much better than the current bill that I've seen. And then as far as the static side, I'll be happy to. Well, I mean, I think I shared. I mean, I'll be able to share. I think I shared it last time too. But what you know, we have. That it's already been studied through the, you know, from other states.
So Benson, you mentioned you were a supporter of 15434, right?
Somewhat.
Somewhat?
Not 100%, but.
Okay. Okay.
Hello? Hello?
Yes.
Yeah, Vantage Advertising agrees with the table so far. 154 was we did a bunch of these roundtable sessions to build up to that bill, and we all thought it was in a really good spot to start moving forward, and maybe there was some fine-tuning that might have happened going forward, but the basis of the bill was, I would say, with all of us, between TriVision, Vantage, and Cherry, we all felt like this was, for the digital, sorry, Benson, but for the digital advertisers, things like the brightness and all of these distances, these were all things that we spoke about back during the 154 public hearings, and it was a very good bill to move forward with, and Vantage supports that.
Sir.
Yeah, we at Cherry agree also that it's a good launching pad for it.
Okay, well, I want to work with the, the author and the chair, and I whatever other concerns that we may get from other community. I mean, obviously, and of course, it makes sense, right? What we have before us today in this roundtable again are those who have vested interest, and not only having had a vested interest, but also, to give you the credit that you deserve, you navigated the process. And you were able to, to succeed in terms of what government regulation was and is in existence right now in order to achieve. But some of it also has been done legislatively, and I agree with the author. I don't think that this is palatable anymore going forward, simply because I think that that's the biggest discriminatory process. With all due respect, if anyone has been able to do that as well. But I think that we need to have a proper regulation. We need to be a jurisdiction like other jurisdictions that have a proper regulation, and that's something that is competitive. I agree with you, Vince. I think this is, and Joe, probably you agree with this as well, is that this should really be a private property driver. I don't think that we should, government should be very careful about, treading in these waters, in my opinion. And I think the general and largest vested interest really is private, and an equal opportunity amongst private landowners who have prime properties that could avail of this opportunity. So, like I said, I'm sure the committee, Mr. Chair, is going to get feedback based on this roundtable. That thank you for scheduling it from others who are interested, and by doing this roundtable, they may submit testimony to the committee and maybe even research 15434 as vetoed, and maybe have some input because they want to avail of an opportunity and highest and best use, at least for their property as it currently sits. I would imagine most of it's undeveloped. Some of it could be developed, which would be the static, on buildings and the like. So, Mr. Chair, I think we're getting somewhere, and I'm just expressing my comfort level and trying to get input for those who are here and taking the time, and obviously, as I said, have vested interest. So that's my questions and comments for this time, Mr. Chairman.
Thank you, Vice Chair. Senator Kaidiwi, you're recognized.
Sijus Masi, Mr. Chair. Good afternoon to my colleagues, and wow, deja vu. We're here again and again. I mean, we talk about 10 years ago that we were going over these bills. No, we were just going over this like 5-6 years ago, and talking about it. And first I want to say thank you so much for all the research that you did when we were going through these bills and talking about, the digital signs and static signs, especially you, Benson. I mean, you went as far as looking at federal regulations and coming up with the distance, and especially for DPW, this was very important because we receive federal funding, and that was one of the big issues that we have to remember moving forward, is that whatever we do on our streets will affect federal funding. And I'm pretty sure, Vince, you can look it up. If you don't, Benson has all that information. Chris, thank you for all the information that you brought forward on the lighting and how much light so that it's not unsafe, you know, that we have on our roads. All you guys contributed, and justfully so, because you have an invested interest. Everyone at this table did more work than any senator I know on what was needed for the island, what was safe for our island, and keeping our island beautiful. So I want to thank you. And we're here again. You know, I thought we did all the work on this, you know, all the headaches that we went through. We took the politics out of this. Because when Bill 154-34, I was not in the legislature at the time when that bill was passed. And Mr. Borja, thank you, because yes, you were part with the Senator Ada in putting that together. And I have the veto message here. The veto message did not give, based on the decision the governor made at the time, did not give justification on the square footage or the amount of distance, specifically one thing, 3,500 square feet. That's it. How did we come up with that amount? So that was something that we continued to work on. Why was the justification? Because that was the only thing in the veto message. 2 paragraphs. It was almost there. It was almost. And that's when we got together in the 35th Guam legislature. That one I was in. So was Senator Terlahi. We were part of that hard work that we went through to justify every concern that we had. That bill, you know, I mean, Chris, you had more hair when we were working on that bill. Benson, you know, you were you look less stressful now than when we were going through it. But it was a huge, 3 bills. And after the 2 bills finally passed, we realized that DPW needed fines and penalties because all these bills that were created did not have any teeth to the game. And still up to this time, there are signs out there, and I get it from you. I get calls from you guys telling me, hey, this sign is up here and it's in violation of the sign bill. Tello, do something about it. I'm like, first I need you to write a letter to DPW, and then I'll back you up, in which you guys did. And there's still signs up there that are illegal today. Tons of them. I'm wondering how a digital sign got up in Alahan. So that's a question I want to ask DPW. How did that get through? The digital sign in Alahan. Money was given from GVB to Alahan to build that sign, but what gave them the permit? So you know what I did? I called DPW and I asked them, and they could not answer it because they said it's political. Yeah, that was the response. So here we are today with the hard work of each and every one of you sitting here today. We're back here to cross out everything that you worked for that had justification. Justification on the distance, on the size, on the illumination, all justified. So I'm not quite sure. And taking away, it was Tay that brought it up when he was sitting on the board, taking away the Guam Land Use Commission is ridiculous. There are more, barriers and ensuring transparency, accountability, safety with Guam Land Commission than DPW. They're the ones that are keeping an eye on everything. And in this bill, it crosses it out. Where's the justification in that? None. So if we're going to work on a bill, maybe we forgot something back in the 35th when we worked on these 3 bills. Maybe we forgot something. So my question now would be to you is, what did we forget to include in those bills Now Public Law 35-18, Public Law 3552, and Public Law 3570. Did we forget something? Was there a new law, federal law, that came up that required a certain, distance, that they were finding out maybe this was unsafe now? They've done more research and found out certain things are more unsafe? So please, when you answer my question, to let me know, what else do we need in this bill to keep Guam safe, transparent, and just keeping our island an island and not the Las Vegas Strip or LA? We're not that. People come to this island for one thing, our people and our beautiful scenery, not Las Vegas Strip. They'll fly to Las Vegas for that. So, Bobby, did we forget something in this bill to add to it? And please, this is a great opportunity, gentlemen. Don't get me wrong. This is a great opportunity for us to go in there and put things we forgot, because I know it was contentious in the 35th. You guys were like on our tails left and right. So please, thank you.
Thank you, Senator. Okay, so thank you, Senator. It's not that I think we forgot something. We had 3 separate bills. When we're all talking about one thing here, we're talking about the sign law. And within the sign law, there are multiple components. We already know that there's digital and there's static. Both showed up on 2 separate bills, right? And then we also know that there's on-premise and off-premise. Mentioned on one, not mentioned on the other. So if we had something comprehensive that looked at not just the distance, the size, the height, but also identified on-premise, off-premise, digital, static, all of those definitions all put into one in consideration of the safety and the beautification of our island and maintaining what we have and keeping a fair playing ground and understanding what the process should be. If it has to be going through the variance process, fine. Allow for new law that clearly identifies what the sign variance should be like, as opposed to having this vague interpretation of the vagueness that's in the law and having interpreted by 2 different AGs at 2 different time periods. If those two sets can be addressed, I think we have a forward process in putting together something comprehensive that easily identifies all those components.
So keep in the Guam Land Use Commission? I mean, you're basically, yeah, okay. And then a separation of between the off-premise and on-premise?
Not necessarily. There has to be a separation. You have to identify what each one means. Because they really identify the commerce portion of view and the non-commerce portion of view, but then also identify saturation.
Right.
If you allow for on-premise to do the same things that off-premise are able to do, then and during the permitted process way, then you're talking about a flood on the market.
What about the distance, that we had in the original law?
Yeah.
What do you think? Distance stays?
I think the distance should be the same for off-premise most specifically, but even for on-premise, really the regulatory aspect is just not, besides beautification, it's for safety, it's for the continued area. And it's not just blocking other signs, it's also blocking investments of building facades. People that have built and block residential neighborhoods. How are you supposed to even know if there's a left turn coming by if you can't see it?
What about the municipal councils, getting involved to approve? Because sometimes when we have land variances and zoning changes, the municipal council steps in as a village. Do you think they should step in and make their 2 cents, put their 2 cents into it?
Well, I do think so, but that's only allowed. I only see that being able to be done through the variance process, through the
land and stuff,
yeah.
but not for signs. It might be something. Okay.
And that's also addressed in the bill.
Okay, Chris, you want to add to that? I know you would add.
The only thing I really want to add to that, and I agree with everything that Bobby said, is that In terms of the municipal planning councils, in this bill, it addresses that they should be aware of it and also get an opinion from the municipal planning councils and mayors. So when an application comes in,
Not an
to
approval,
DPW,
just an opinion.
just an opinion,
But not
Now,
an approval.
Not approval. The ultimate decision is still up to DPW.
Do you think it should be an approval by the municipal council since it's their village and you're going in there to,
I
litter
think so.
their village?
I believe so. I think that they
should be
need
approved.
more power.
Well,
right?
I think if villages too have to approve buildings being erected, like Chalampago.
Yes.
That was a big issue
Pago Bay,
there,
yes,
putting
Pago
up
Bay,
a sky, a certain amount of condos in like 15, what was it, Benson? They were planning on building a hotel down there in Pago Bay?
Pago Bay, yeah.
Yeah, okay.
Yeah, so,
Right on.
So in terms of municipal planning councils of Guam, it's really important to get their opinion and also their approval because they're the ones who manage their villages, right?
Okay.
And that was one of the really good things about the GLUC having this approval process because they took that as law. Like if the municipal planning council didn't want it, then they weren't going to approve it. Simple as that. Now,
Mr. Chair, as a point of order, I think I'm a little confused here right now because the representations of the current senator who has the floor is that that in the 35th legislature things were fixed and 154 didn't become. The contents of that didn't become law in the 35th
No, it was
Guam
in the
legislature,
34th
right?
Guam legislature, Senator.
No, I understand, but what I'm saying is the representation that you're making is that there's things that were fixed in the 35th Guam legislature, but I just want to make sure that 154 in the 34th Guam legislature didn't become law in the 35th, right?
No, didn't.
Okay, because that's
And
why
I have
asked.
and I read the veto. I was
Yeah.
mentioning the veto message by
understand.
the governor at the
I
time,
understand,
but
Senator.
it passed.
I understand, Senator, but that's why I was
Passed.
asking, is this a good launching point? Because the bottom line is, everyone here said that this bill is really what we should
Yeah.
be working on, but I just want to make sure that people aren't confused that in the 35th, all these things were fixed in 154. We just had a representation by the gentleman that there is in 154 the requirement for disclosure within the community and the community acknowledgement of.
only an opinion, though.
Right.
Only an opinion from the MPC.
Only an opinion, yeah. If I may continue.
So we can work on
Okay.
it. Yeah, but I just want I
So-
just want us thinking that
Yeah.
in the 35th Guam legislature, 154 actually was enacted into law.
No.
So we were talking about the other three bills
No,
in the
it was
35th
not.
Guam legislature that we are trying to move forward with, and that's basically what's happening. Is this bill is striking out everything that was worked for in the 35th. So other than that, yep, you made it clear. But I'm not going to keep taking up time because I know Senator Terlahi was also present during the 35th Guam legislature when we were going through this. But if there's anything else anybody wants to add,
Well, there's
before I go.
There's
Yeah,
one more
go
thing I
ahead.
wanted to say about the GLUC. It was a great process because everything was so transparent. We had to get approvals from mayors, mayor councils. We had public hearings. We had to prove that it was safe. It was viable for the location as well. The only thing that I saw that was lacking of that approval process is the regulations. They weren't guided by, the board wasn't guided by regulations. So if a sign applicant came in, they would say, okay, this is what we want to do, and then prove that it's safe and that it's acceptable by the village. But then there's no regulations in terms of size, distance in between signs and things like that. So that's, if the GLUC was to be given that power, I would recommend that there be also regulations that they would follow for that, the basis of approval.
Yeah, I just want to add that, you mentioned about the GLUC, the process is very, tedious. Besides the municipal, the mayor's, not approval, but opinion, right? You said that, you have to go to the mayor, you have to go through agriculture, GBW, PUH, like 14 different, departments to get their, if there's any objections from them. So, it takes like maybe 6 months or something like that. And then a public hearing with the community that lives around there, 500 feet. You know, then you got to put in a newspaper and a whole bunch of stuff. So, you know, I mean, it's just like changing a height variance or parking variance or anything like that, you know, that it goes through so that there's no objection from the community before, you know, you can put something out, you know. I mean, if you talk about blocking somebody's house or business or something like that, I mean, those are the opportunity for people to come up to, you know, to say things. So, I mean, it was working at the time until we get that, you know, the AG opinion, right? And regard to the bill, you know, I mean, the veto bill was, you know, for the most part for the digital, you know, information, it was very studied. It was very put together by, you know, the digital people. You know, generally it's a very good information for the digital side. You know, I just want to point out that that, you know, at that time, you know, when they put it together, they kind of just lump sum the static sign and the digital sign as one rule for all. And that's the only one. That's the only thing that I always kind of explained out. You know, that there are two rules for two different, because they're not the same sign. I mean, on-premise sign, off-premise sign, they're not the same. Digital sign, static sign, they're just not the same. And that's why the, you know, the matrix that, you know, the association brings out. I mean, these are good information that I think, you know, I don't know if, I think I supplied it before, I don't know, but, you know, I'll be happy to provide again for you to review, for, you know, to better. And again, I think everybody sits in here are the most responsible sign people. I mean, we don't just, you know, throw a banner on a wall and, you know, call it a day and, you know, try to sell something. I mean, everybody did it, you know, the right way. You know, it's engineered, it's type improved, it's proven already, and, you know, it's been set for many years. So I think, you know, we'll put our head together. I think we can hammer out something that will work.
Thank you, Vincent. Can you please give a copy to our chair so he has an opportunity? Oh, there. Okay. Okay, Mr. Chair, I appreciate it. Again, I appreciate what you guys have been doing, and hopefully, if there are these little clumps in between, I'm sorry, was there anybody here wanted to, okay, that we need to go in and adjust, we adjust for the betterment of Guam on those three. Thank you, Mr. Chair.
Thank you, Senator Tideway. Senator Chalahi, you're recognized, ma'am.
Yes, thank you. I appreciate all of you being here and your input. So we are here, and the agenda was noticed and advertised as on Bill 175, which there was some objection to at the earlier public hearing. But another bill from a previous legislature has been brought up, and we're seeming to have a discussion on that. I think that we should have a notice if we're going to have a different bill to discuss. But I appreciate that, yeah, we all agree that there are different issues that have to be clarified. And before I go any further, I'd just like to know, we have a lot of the digital sign companies here, one of the static sign companies here. Which of these companies, how many of you have received that sign variance from the Guam Land Use Commission that was later determined to be ultra-virus or outside of the law or illegal at that time, and then was grandfathered in with a subsequent law? How many companies received that variance? Everyone at the table?
I believe every variant, every sign variant.
Okay, so there are, so the digital signs that are up right now are pursuant to that variance, correct?
Yes.
Yes. And then, so since then, the only law that we were able to put in and allow was this one that we passed for the hotel zones. In a hotel zone now, digital signs are allowed. Everywhere else on Guam, the current status of the law is digital signs are not allowed, except those that were grandfathered in by that exception. And off-premise signs are still not allowed, right? Except those that were grandfathered in by that exception. And digital signs are now allowed in the hotel zones. The current law says only for on-premise still. And DPW was supposed to do rules and regs. Can I just ask what's the status of the rules and regs? Are there rules and regs for the digital signs in Tumon? No, ma'am. Or in the H zones? Not yet. Okay. I kind of think that a lot of the things that are being discussed as to the regulations, I agree. It's either we put regulations into law or they're determined by DPW rules and regs for what's authorized by law. But we do have to either put it into law or we were allowing GLUC without any kind of guidance to make these determinations. So I absolutely agree that we should have a signed law that says whether we allow anywhere else besides the H zones off-premise signs, right? One. And it should say very clearly, if we are going to allow those in a static form, these are the rules. If we're going to allow them in a non-static form, these are the rules. I personally don't know. I think that's kind of a future decision to make, is we should allow the GLUC after that to allow variances on even those rules, those kind of size limits that we make. But those have to be made. Otherwise, the GLUC has nothing to base itself on, and we will have kind of unfair, and I think that's the feeling, right? People feel they're not able to enter into this type of business, or they can't compete because they didn't get the variance, they can't compete, the prior variance, they can't compete because they weren't the first person within 3,500 feet, right? According to that old bill that was proposed. And that's first come, first serve within the next 3,500 feet, no one can put up a sign, and that's kind of forever, it looks like, right? So I think that's something big that we need to discuss, but the bill, 175, as many of you pointed out, removes even the regulations that we came up for the H zone and for digital signs, which I think were reasonable, but the bill proposes to remove, the lumens regulations, the size, whether it has to be on the building or not, and then we're going to come up with a lot of problems, as I think, Benson, you talked about, or many of you talked about, blocking other people, doing all of that, and then the audible, all kinds, and then it's like jungle rules. So I thought we were very strict because we were also, GVB opposed that. They thought it was going to make Tumon look ugly. And so I think that's still very legitimate. And so I thought, we have to see how that works. It would be helpful to see the rules and regs from Public Works and see if it is ugly or not before we say the rest of the island should become that ugly, or it's going to still be beautiful. So I think maybe I would just, we need to tackle one thing at a time in these roundtables. For example, off-premise versus on-premise, right? Is there harm still in off-premise signs, right? Like on your commercial building, can you put somebody else's business product? Can you advertise? Is there a harm in that or not, right? We know there are harms in putting digital signs in certain places. We know there are harms even putting static signs in certain places. We know there are harms because of traffic. So we want to I think we can shortcut by DPW coming up with the best practices across the nation. These businesses have proposed that these are the best practices across the nation. The one I don't like is that first come, first serve, and then everybody else, they're out of the business. They can't adjust. Some people testified in favor of the bill, and they would come in and say, yes, because I want to put signs on my commercial building, but they don't know that they won't be allowed that because there's already another sign within that 35. I'm curious to know how long Marine Drive is. How many 3,500 feet how many signs can we put up on Marine Drive from Agana to Tamuning, for example, right? Just very concrete numbers I would like to see so that everybody understands. Benson might get his up, you might get yours up, but that other person, the ones that came in to testify, they might not get theirs up at all. But otherwise, I think we all agree we need to have parameters going forward, but I don't think we should be, I don't know, some of those, I don't even think I voted for that H zone bill, but I did do a lot of work to make sure that the concerns that were made by the community were put in there, such as, Yeah, very, very practical. The lumens, the distance, the effect on the ocean life, right? Things like that. So I don't agree that those should all be taken out. I think we should just decide first, is there a harm in off-premise signs? If not, maybe we can allow off-premise signs, right? And then make the parameters for that. And then if there is a harm in digital signs, we have parameters for that. We have traffic, at least we have traffic parameters and distance from each other parameters. Now, Guam is small. I just feel like we were gonna have different results here than we would in maybe in other places. Even our traffic lights aren't that far apart, right? But yeah, so there's a lot of talk of leveling the playing field. So I think what you guys mean is to make legal what's currently not legal, because some were made legal, right? There's a few exceptions, and that is really a problem. But so I think it's better if the legislature or Public Works, through rules and regs, comes up with clear parameters for off-premise static signs, clear parameters for digital signs, but I just, that level the playing field, I feel like it's going to be even more problematic when we start coming in with distance requirements between signs, and so that limits the number of businesses that are able to put up signs. I think one of you or some of you said there should be distance between even on-premise signs because of saturation of digital signs. Wow, we didn't restrict that in Tumon right now, right? So they could put up as a digital sign on every building is what that law allowed. Yeah, so I share your concern and GVB's concern. So I don't think we fully resolved it all, but it was legalized down in Tumon. So that's kind of like our testing ground. But so for what it's worth, I'm totally willing to continue working on these signs. I want, I understand businesses want to advertise, period. That's the bottom line. So we should allow that, but I just think we have to be very, very careful. We have been in here every month almost about GVB, how are they gonna, bring us back, bring us our tourism back to life. And I just don't want to shoot ourselves in the foot by making us one of the ugly destinations. And there's a dispute as to that, right? It's just a difference of opinion as to what's ugly, what's not. But again, Mr. Chair, so I appreciate the roundtable format, but I'm just thinking, because we're even discussing all different bills now, there's just too many factors. Like, let's get two or these factors down, and then we move on. If it's digital signs, regulations can be standardized, right? If it's static signs, regulation. Benson's really done us a lot of work on showing us the different standards around the nation. Others have to. But we have to pick what's good for us here from that. Thank you.
Thank you, Senator Talahi. And you see, it brought Senator Talahi out again, saying, hey, we're going to move on working on this. Senator Borja?
What's that, Mr. Chair?
No, I said, see, it brought you out again to say, yeah, we're going to continue working on
Well, we've been working very hard.
Yeah, absolutely.
Yeah, ask Benson. He's my old friend, and yet he's been mad at me a couple times because we couldn't move fast enough. But it's just a matter of balance, So yeah. We are also, we want to put digital signs, but we have to balance,
That's just happiness.
And I don't agree with we're going to allow any more without a law that allows them, kind of a default, let's jungle rules it. No way. Thank you.
No jungle rules. Senator Borja, you're recognized.
Thank you, Mr. Chair. I don't like to ask questions when I don't know the answer to them, so I don't really have any questions. But obviously, listening to, of course, the comments and feedback in regards to the proposed bill and then the vetoed bill, obviously, there's definitely a lot of work that the committee is going to have to do. And for me, of course, it's always safety and how it's going to be regulated. So I really just look forward to working with the committee chair. And I think, this was a smart move in regards to having the roundtable before the public hearing, because obviously there's a lot of questions and ambiguity that we need to address. So, really thank you for coming down here and you guys' comments and feedback. And I look forward to the committee work with the chair. Thank you, Mr. Chair.
Thank you, Senator Borja. We did have a public hearing, but this roundtable was to bring everybody back to the, see how is it that we can come up with something that's viable and doable for everyone. Senator Dueñas, you had any, Vice Chair, you had any other comments?
Yeah, this is just Masi, Mr. Chair. Just once again, great dialogue, I think. I wanted to reiterate, and this is just my opinion, it can be disputed once again, but I look at a roundtable process as a working group. And I don't think anything's off the table. There's a lot of work that went into this, as discussed by all the members here in 154. And it's clear to me that 154, in any other legislature since the 34th, nothing's come close to what the work was put in this bill. I think it's very germane to use this, and since we got consensus, as the launch point to do what other senators are talking about, to create regulation. And so I just want to continue to reiterate that, Mr. Chair, that I think it's very germane. This is a bill that passed the 34th Guam legislature with notice, with roundtables, with workup. This is not just a bill that came flying out from some other group of people and said, hey, why don't you do this? It was duly passed and vetoed. That's fine. It wasn't overridden. And in its format was never taken up again. That's what I see the frustration of everyone that's come here that said the 34th did this work. It was vetoed. And since then, there have been minor tweaks to the law, but nothing coming close to the work that everybody's praising you for that you had done in the 34th. So, Mr. Chair, once again, as your Vice Chair, and I'm willing to do the work, I think this is a very reasonable launching point. And this will address, probably the first question is, since the veto message only said 3,500 feet, how did we get there? I thought I heard that answered here, that's standard in other jurisdictions. And so, Mr. Chair, once again, I just want to reiterate that I would like the committee to have another roundtable, another working group coming together, and if we agree within our committee that we adopt this as substitute legislation to the current legislation as a launch point to build out from it, that's the prerogative of our committee. And that representing if that's what our committee meets on and we decide to do and schedule another public hearing or another roundtable, that be the privilege of the committee, because this is a good piece of work. I don't want to throw something out that all of you worked on hard, because other than that, you know what I see? I see a common theme sometimes in the legislature where everything's too hard. And so you scrap work that was done in order to just start from scratch, and then you get nowhere again. You get the 35th, the 36th, the 37th. Now we're in the 38th, trying to do something. So I just want to put that on the record, Mr. Chair.
Mr. Chair,
that's what we should do in our committee, and if that's the will of the committee, we move forward.
Mr. Chair, if I may, this committee, and just for the listening audience and for you to realize that the committee doesn't have everybody. Not all senators are part of their committee. And Mr. Chair, I'm hoping that because it's so important, and there's many of us who are not in your committee, but who worked on this legislation in the 35th Guam legislature. I wasn't here in the 34th, Senator Chalahi was in the 34th. So I'm asking that if we're going to continue on, that we continue on as a roundtable discussion and not leave out senators because we are not part of your committee.
And I think you brought up, the Vice Chair brought up a good point about having another roundtable and then perhaps another public hearing. And regardless if you're part of the committee or not a part of the committee, right? Your input, whether it be in this public hearing room or on the session floor, is where it comes in as well, right? So that's,
Yeah, I'm just saying
that's what
because
we
they're already
described.
voting on it. You're deciding
Negative. I
as a
don't- Mr.
committee
Chair, point of
to
personal
go on
privilege.
this.
I do
Wait,
not
I have
want
the
to have
floor.
my
Let me
words-
just finish my
Excuse me, no,
comments.
no.
Let me
You're
finish my
trying- you're
comments.
trying to put words in my
Maybe
mouth,
Senator
Senator, and that's
Duenas, I
inappropriate.
misunderstood
That's
you,
not
but
the
this is
comment
what
that
I
made.
understood.
Yeah.
This is what I understood. That
Well,
your
you
committee is
understood
going to
it
vote
wrong.
on certain something, and we're not going to have the ability to put in our 2 cents.
No,
You know,
that-
so I just hope that before you vote on using whatever guidelines in this bill as a guideline, that before you do that, we have our meetings
And that's
as
where
a
the-
whole and
that's
not
where
a
the vice chair
committee.
has said, the vice chair exactly said that.
That's what I
having-
wanted to
yeah.
make sure.
Yeah,
And I'm
that's
putting it
exactly
on
what
the
he said.
record
No, he did
just
put
to
that on the
ensure.
record, yeah.
No, well, I'm putting it on the record to make
Yeah.
it clear because people don't understand what committees are.
Yeah.
You know, and just like everybody wants to know, like I have a committee, but you know, certain senators are not on my committee. But whenever I do markup meetings, I invite all senators to come to my markup meetings, but other senators who have committees don't invite all senators, only just a few that's in their committee. So people need to understand that. Because if they're wondering why we did not put our 2 cents in, wondering why we were not part of it, then they understand the situation.
Okay. All right.
Mr. Chair.
Senator?
I just want to clarify. There has been things passed since that bill that's being proposed, and that's what I think we need to reconcile. And that's why I think when we're having any roundtable or public hearing, we give notice, we give adequate notice of exactly what it is what we are discussing right now. The notice that went out is that we are discussing just one bill. And if we're going to switch it, I just ask that notice be very clearly given that the bill's been substituted or whatever you've done, and that's what we're going to discuss.
Yeah.
Because both bills, the new bill and that older bill that was vetoed by the governor, if just adopted right now without harmonizing what we have passed and put into law since then, are going to pretty much repeal what we have in law without giving any notice. And I think that should be done. It should be very, very clear.
And that's where absolutely Bill 175-38, this is what this roundtable was about, 175. It was the stakeholders that brought up the previous bill and the legislation. That's what this roundtable was for, to find out where is it that we can come to a medium and moving things forward and not being stagnant and saying, okay, well, this ain't going to work. We're not going to do anything. So at least it brings now a working point as to what is workable, what's not workable, and how we can get out of this situation, right? So if there's going to be any complete substitution of the bill for a 154-34, absolutely, we will have another hearing on it. And that's what the vice chair has mentioned, another roundtable and perhaps another public hearing on this issue. So that's what we're gonna go ahead and continue to work with.
Can I ask, Trivision, Benson's, and of course Cherry, did any of you write this bill 175? Did any of you know about
absolutely,
this
none
bill?
of them. None of
None
them
of them
did,
knew
yeah.
about this bill,
Right.
right? So how did this bill come about is
It
a
was
question.
a constituent that brought it to my
Okay.
attention as well. So,
Okay, thank
yeah.
you.
Not a problem. And that's what we'll continue to do. We'll continue to work on it and see how we can make it a better piece of legislation. Like I said, the end game is to make it fair and equitable to all. Whether you're in digital sign, static sign, whatever sign, let's try and update our sign laws so that we don't have to come back and revisit this again, so that we can go ahead and move on to other things, right?
Could we also, Mr. Chair, get a follow-up, if there's going to be another roundtable from DPW, as to whether there are going to be any rules and regs for the H zone? Because I think in their reviewing and preparing rules and regs, they will also be able to bring up whatever they are not able to enforce, or whatever limitations they have in enforcing any of the restrictions, so that we know with confidence in allowing it for other places, whether it's enforceable or not, from DPW.
Can probably work on that and email it to us, yeah. All right, so that will conclude this roundtable, and the committee will continue to accept written statements on today's roundtable from 7 days, in which can be mailed to my office on the second floor of the Guam Congress Building, 163 Chalong Santo Papa in Aganya, or you can send it to us at Vice Speaker Tony Ada at guamlegislature.gov. I'd like to thank all of you again for being here for this roundtable discussion on bill number 175 5-38, and the time is now 3:39 p.m. Thank you all for being here.